Okay, Assalamualaikum. My name is Amira Ilyana Binti Zulhazmi with Matric number 256052. I will be explaining regarding with the Dworkin's right thesis, focusing on the criticism of the right thesis. So the background of the story is regarding to the Dworkin's right thesis. First, the judge plays important role in the legal system. So how does the judge decide on each case? So the Dworkin observed this and came up with his theory right to answer. So his right thesis involved a general claim with the legal principles and proper understanding of nature of law. Rights are more fundamental than legal rules. So his theory totally opposed to the legal positivist idea in the legal system. There is always a right answer to a case. So as judicial decisions are specifically generated by the legal principles and enforces existing political rights. However, to Dworkin himself, judges may come up with a different decision as the judge has the right under the law that is his judicial discretion. It can be said that judges fills in the gap left by rules by using his discretion power. However, this rejects the Dworkin theory. So according to Dworkin's theory, right to thesis, there is a concerning on the judicial discretion. So what does this mean by the judicial discretion? So it is a judge's power to make a decision based on his or her individualized evaluation guided by the principles of law. So basically the judge will make his decision based on the law, but however it is added to his discretion power. However, according to Dworkin's idea on the discretionary power is, the discretion is not the freestanding but a part of the process. So discretion is like the hole in a donut, does not exist except an area left open surrounding the belt of the restriction. However, the discretion is not outside the law but internal to the law. If the judicial decision was making unfettered decision, we would have to say that it is no special role of judges beyond being a political and administrative officer. So if judges were unfettered lawmakers, they would have to be democratically elected. It is been known that Dworkin has an alternative theory. The first step is to make a distinction between the strong discretion and the weak discretion. The strong discretion is where the officials are bound by the pre-existing standards set by the authority, and the weak discretion is where the standard cannot be applied in a mechanical way. There is a need to evaluate what the standard means in a new case. So in a weak discretion, there is no gap in the law. Strong discretion does not exist for judges, and the weak discretion is a part of the judicial role. Then the discretion is controlled and there is no gap in the law. However, H.L.A. Hart says that this is one of the legal scholars in the jurisprudence, says that the judges exercise strong discretion in hard cases. That seems to adequate. The HLR seems to say that the rules plus the discretion equals to new rules. However, the H.L.A. Hart theory critiques this Dworkin right to thesis. So here we can see that the rules have a different meaning and different effect when you apply to irrelevant principles, where policies are the collective goals of society pursued by the legislature, democratically elected. Principles are internal to the law and are developed by the judiciary. So the rule that a person may not benefit from his own wrong is a principle which is found throughout the law. So in every adjudication of hard cases, there are controlling standards which the judge obligated to follow. There is not mean necessarily for the power of discretion power given to the judge. So there is a rules and standard that the judge must be bound to follow. So every adjudication, he cannot be simply make his own discretion. So we can refer to the case of Riggs against Palmer in 1989. The Elmer murdered his grandfather in order to inherit his will. Had the court taken the positivist view, then all the laws are valid by the former test. As per the H.L.A. Hart thesis, the court would most probably decide in the favor of Elmer. However, the court did not allow Elmer to profit from his own wrongdoing. The decision proceeded not on the rules but on the principle of law, that is, no one can profit from his own wrong. If the law is taken literally, so Elmer would be entitled to inherit his will. However, he murdered the grandfather in order to have the inheritance, so that the law make this decision so that the Elmer could not have the will. Dworkin distinguished rights from the rules. So the rights are more fundamental than the rules in a legal system. Rules as prescribed by the right exist before their expression in the form of rules. This is opposed to the Hart's view where rights develop from the legal rules. The reason why Dworkin says this because rights are more important is because rights develop in the legal system through the working out of the political morality. Now we'll be looking into the main criticism by the various jurist scholars who criticized the Dworkin's right thesis. So according to McCormick, the proposition that the judge have a weak discretion and that they are to find the right answer from the principles is unsustainable. And also according to Greenwald, he quote that the denial of discretion is wrong and inconsistent with our ordinary understanding of judicial responsibility for opinions. He suggests that the judges have discretion is not to imply that they have the license to do whatever they want, to do whatever in their will. The institution of judging offers the judge choice only within the constraints of judgment. So according to the Stephen Guest, the Dworkin's thesis is not his own making but it has been ascribed to him. It can be said that what Dworkin meant to say was that there is a possibility of finding the best answer. So in his other words, the judge is given the hope that he must not give up thinking that there is no best answer at all. Another argumentation raised by Greenwald is that in a case of nuisance, so the judge may consider the effect of his discretion power on the decision on the community before accepting the rights of a claimant. So such cases indicates that the judge do decide on policies while determining the rights of an individual or the claimant. So other scholars also criticize the Dworkin's thesis on the ground that the right thesis cannot be demonstrated as there is only one right answer to a question. So if we refer back to the Elmer case as I mentioned before, if in a case of supposing two judges are to decide whether Elmer is entitled to inherit the grandfather property, they may answer this question differently from each other and yet claim that their answer is the right answer. So there might be a dissenting judgment, or might be a ground of judgment that is given by the law. So in the mind of a public and in the mind of the legal scholar, how do we demonstrate as there is only one right answer to a problem? So if we refer to this Dworkin's right thesis, this might be a problem. So if we relate to the nuisance situation in the reported cases in Malaysian law, the Chin Moyen versus Chai Weng Seng, it is a civil action by the plaintiff against the defendant based on the thought of nuisance. It was basically alleged that the defendant was liable for the nuisance of the plaintiff by causing or allowing excessive noise to emanate from the unit and also vibration of the walls on the said unit. So, however, it is on the issue of recalling the witness at the appellant stage. So, in line to the judicial discretion and to this assignment, the exercise of the trial judge's discretion depends on the justice of the case, so having regard to the peculiar facts and circumstances before the court. So the trial judge must also be given very wide discretion on matters relating to the evidence. So however, the decision of the court is the court does not allow the civil action by the plaintiff because basically it cannot recalling witness. However, if we relate to this discretionary power, it shows that the judge have the right to either allow or disallow this application based on the basis of the circumstances and everything and etc. So in my conclusion, the Dworkin's right thesis wants us not to relent but to make the utmost effort to get the best answer. So it is a sort of idea that the Dworkin seems to present the judge in a practical pursuit. So as per the Stephen Guest, he quoted that the judge may not get it right, but the duty is upon the judge, is upon him to try his best in deciding the case and get the right answer. So Dworkin's work in this thesis has constantly been concerned with the judicial interpretation of law and the role of a judge. So Dworkin is clear as to the political values he committed to. So he stresses the right as approach over the utilitarian calculations. So this is all from me, and according to the criticisms of the Dworkin's right thesis, I have listed down all the criticism. So that's all for me. Thank you.